Good morning. My name is Hank Zuber. I am a state representative from Mississippi, and I will be co-moderating this session with Representative Jeff Morris. Representative Morris is from Washington, and he will be running about 10 or 15 minutes late, so I'll go ahead and commence the session and start the program. Good morning again. Welcome to the session, Online Threats and Dangers. Can the Law Keep Up? I will be moderating our program today along with Representative Jeff Morris, as I mentioned before, from Washington. I serve as the Vice Chair of NCSL's Communications, Financial Services, and Interstate Commerce Committee, which is co-sponsoring this session. Before we begin the session, I have a couple of announcements. First, please join me in thanking Dell, who is providing the coffee break, and it is most welcome. Let's give them a hand. Secondly, today's session will be streamed live on the web with the help of our friends at the Ohio channel. The session can be viewed live both on NCSL's website and on the Ohio channel website, and an archived version of the session will be available after the meeting as well for those who have an interest. Keep in mind that the camera will be live throughout this session. We would like to remind all panelists and presenters to please speak into the microphones. If you would like to ask a question at the end of our program, please use the microphones in the room. Also, as a reminder to the attorneys in the room, this session is eligible for continuing legal education, i.e. CLE credit. The CLE sign-up sheet, the agenda, the biographies, and the handouts are located on the handout table in the back of the room. If you are seeking CLE credit, be sure to sign up on the sign-up sheet. Information, and go ahead and present that back home, and you can get the CLE credit for attending the session. In our program today, ladies and gentlemen, we'll discuss some of the topics of online threats that have made headlines recently, such as revenge porn, as well as other new and continuing concerns related to online threats and safety. We'll discuss approaches that the various state legislatures are taking to combat these new challenges and the complex issues that they bring up within the state legislative process. I will go ahead and introduce the speakers. Their full biographies are available on the handout table and on the NCSL website along with the handouts. We'll begin the program with presentations by our distinguished panel of speakers, followed by an approximately 10 to 15 minute Q&A session. Please hold your questions until the very end of the program. I'll go ahead and introduce our distinguished speakers, and then we'll give them a chance to provide a 10 or 15 minute speech, and then I'll go ahead and introduce the second and the third speaker, and then we'll take the questions. Okay, ladies and gentlemen, our first speaker today is Jeff Williams. Jeff joined the Counter Threats Unit of Dell Secure Works in December of 2012 as Director of Security Strategy, focusing on investigation of emerging security threats, cross-company initiatives, and productive response efforts. Prior to joining Dell, Mr. Williams spent more than 12 of his 20-plus years in the IT industry working for Microsoft, where he held a variety of security and privacy positions. Mr. Williams is a frequent presenter and author and has served as an adjunct professor of risk management and telecommunications. Mr. Williams, the floor is yours.
Thank you. Thank you for the introduction. So as mentioned, I'm a senior member of the Counter Threat Unit at Dell SecureWorks, and our focus is on proactive security measures and investigative research on emerging and current threats. The team engages directly with the FBI, computer emergency response teams around the world, and other security researchers in both academia and industry. My background includes extensive security consulting at Microsoft and before, as well as privacy work. I was divisional privacy officer for one of Microsoft's divisions, and then a senior member of the anti-malware team when Microsoft entered the antivirus space. I also have taught in a number of forums, risk management as a professor at the University of Phoenix, but I also teach children about security and privacy because I have such passion about the topic and because it's such a poorly understood area, particularly at that level. The work I do and the work my team does, I think, is probably some of the most interesting in the security industry. We operate from open source intelligence, things we can find on the internet, and also things that we gather from our customers in the form of event logs that occur on their network. Our clients provide numerous events to us, billions per day, that we analyze, aggregate, filter, and try to understand not only what is normal in a network, but what is an aberration from normal, so that we can understand the tactics, techniques, and procedures that attackers are using to infiltrate these networks. What we learn, we share with the community, the research community, in the form of papers, presentations, classes, white papers, and so on. But we also use that information to create countermeasures to protect our client base. Additionally, our research, our sharing, our partnerships extend to law enforcement, where we work with the FBI and law enforcement around the world to combat these threats, such as with the recent takedown of the Game Over Zeus botnet through Operation Tovar. And what we've seen in our research as we've gone through time is an evolution. In the early days, throughout all of time, there's been a profit motive. It's kind of the Willie Sutton model, go where the money is and go there often. But in the old days, it was stealing a single credit card, faking somebody's page to get somebody to enter credit information and then use that information fraudulently. But over time, more and more bad actors were doing the same thing, stealing that information, and suddenly it became more difficult for the criminals to make money, and so they started to evolve. Instead of stealing individual credit cards, they would steal larger and larger numbers through the use of malware with keylogging capabilities and similar. That led to an inability to directly turn that into profit, and so they began selling the excess of their credit cards, stolen information, to other criminals who might be better able to monetize. As more and more actors emulated this tactic, the market was flooded, the price per card was driven down, and criminals had to go to larger and larger batches of credit cards in order to make the same kind of money that they had originally. So this evolution takes us from the nuisance threats and hobbyists and individual criminals doing small numbers of crimes to larger and larger thefts of information, not from individuals, but moving to credit card processors, retailer networks, and other places where information is aggregated into databases of financial information. But also during this time, we see criminals starting to help other criminals hone their craft. The techniques get better and better, the tools get better, and specialization starts to occur. Criminals with specialist skills are selling those skills as a method to monetize their criminal interests, as opposed to doing the crimes directly. To the point where in underground marketplaces, it becomes possible to assemble end-to-end an entire attack campaign without having individual skills yourself. This leads to larger and larger crimes, to what we've seen today with hardware-based attacks, to attacks on point-of-sale networks, to attacks on franchisees of various entities, UPS, whomever. And the larger databases become more and more attractive. The monetization of those databases becomes simpler in the underground marketplaces. The research activities that go to countering these kinds of threats become more difficult as the criminals have understood those processes and introduced anti-researcher techniques, such as vetting of membership in these underground forums, such as the creation of encryption and packing layers to obfuscate the malware that's being sent out so that it is not detectable by antivirus software during the period of the major attack, and so on. But at the same time, security has gotten better. People have a better awareness that there are threats out there, and organizations, companies are doing more to protect their networks. Is it enough? That's an open question. But the techniques are there, the services are there, the skills are there. They simply have to be employed. And one of the ways that we're employing those skills is to share our knowledge with other researchers. And it's a lot of information to share. So we do malware analysis, we analyze customer events, we look at the communications that the botnets themselves are doing, we look at public and private feeds of data about threats in the world. We have strategic relationships across industry, academia, law enforcement. We operate our own honeypots to collect information about what happens during infections. And we do our own research looking at the attack techniques being used by different actor groups, and as much attribution as possible between a particular piece of malware and the parties responsible for it. Even if we can't identify them by name, we can see the patterns of their attacks, and we can understand this attack, and this attack all came from the same actor group. Unfortunately, the criminals also have their private lists of sharing. They continue to improve their skills. It's a game of cat and mouse, or missiles and anti-missiles, if you would prefer. The challenges we face as an industry, as a world trying to protect the internet are great, but we also have gotten to a point in time where the right people have the right information and are sharing it, where there are strong, productive partnerships between industry and law enforcement and academia and individual researchers. And those partnerships and those relationships are being put to good use in the form of takedowns, such as I mentioned with Operation Tovar earlier. It's not always apparent how much cooperation is going on in the security space. A lot of it happens behind the scenes. But we use that information to do something that we refer to as breaking the kill chain. In any attack, there are multiple phases of the attack, and it's only that end phase where the criminal gets what they are looking for, such as a database of credit card information. First, that attacker has to do reconnaissance. They have to develop the techniques that they're going to use to attack that environment. They have to weaponize in some form, whether that's malware or a targeted phishing campaign or something, deliver that to the intended target, exploit something in the network, install their software, institute command and control, and then they can take actions on their objective. There are a lot of places we can disrupt these activities. If we first know their methods, we can predict what's going to happen. The earlier we can detect it in the kill chain, the more we are able to resolve, the better the countermeasures are put in place, the more effective they will be. Stopping the attack before the objectives are met becomes a critical component of security today. And finally, the eradication of the threat actor from the environment once they're detected becomes a critical component as well. I believe I have a hidden slide, pardon me. And I've talked about some of the relationships. I've talked about how they're not necessarily visible, but there are a huge number of collaborative resources for security researchers, whether that be industry relationships such as we have with Microsoft's Active Protection Program or the Forum for Incident Response Security Teams, or whether that's with law enforcement such as the Secret Service, FBI, Interpol, and so on. These relationships exist today. They are flourishing. They have great communication and information sharing, and they are targeted on actions against the criminals responsible for these attacks.
Thank you, Jeff. That was very informative. Our next speaker is Ms. Lee Rowland. Ms. Rowland is a staff attorney with the ACLU's Speech, Privacy, and Technology Project. Ms. Rowland has extensive experience as a litigator, lobbyist, and public speaker. What a combination. Prior to joining the ACLU, Ms. Rowland was a voting rights counsel with the Brennan Center for Justice. She previously ran the Reno office of the ACLU of Nevada, where she would regularly argue before the Ninth Circuit Court of Appeals and the Nevada Supreme Court. Ms. Rowland is a graduate of Middlebury College and Harvard Law School.
Thank you, Representative Zuber. I'm taking my phone up here to make sure I don't overtalk, as I am wont to do. Okay. Thank you so much for having me here, and thank you for the introduction. I'm going to switch gears a little bit and talk about some of the more hot-button social, I think, issues that are implicated in online threats and dangers, where there may be civil liberties concerns. I suspect most of you are familiar with the ACLU, but to give a quick overview of where I fit into the ACLU world and how we work on the state level, I think that would be helpful. So I am an attorney at the Speech, Privacy, and Technology Project, and the fact that we put speech and privacy together is not a coincidence. It is, I think, fair to say that privacy fundamentally involves control, right? And especially online, privacy is about controlling what other people can do and say about you, which is inherently about speech. And of course, the internet is made of speech. So it's frequent that laws that target privacy online, and we support those goals, may have implications for speech. So it's very important to be thoughtful about that line. That's what we try and do at the ACLU nationally, and that's why our project encompasses both of those constitutional rights. As far as our structure, the ACLU has an office in each state, and they are independent entities. So I worked for the ACLU of Nevada for many years, where our policies sometimes differed from other state affiliates and the national office. Frequently to respond to priorities and character of the individual state. We frequently come in at national when we're asked to advise the affiliates, to share information about what's going on nationally, to let them know how we've handled thorny issues. Some of the thorniest issues we deal with, I grapple with. I really work at the intersection of speech and technology, and speech and privacy, particularly in the technology context. And we do our best to untangle those in a way that we think honors both the right to free speech and honors the very important value and right of privacy. So the really tough ones, literally the questions I was asked in my job interview, are every topic that you see listed in describing this session. The absolute, I think, most difficult question that the internet has presented us with are things like revenge porn and online harassment, and how we find the balance between protecting free speech rights, particularly speech about matters of public concern that the public has a right to engage in, and how we protect privacy when the digital world makes invasions of privacy so much more permanent and so much more cumulative, and that's real. These are all real concerns in all of these issues. And I've done 4-hour sessions just on revenge porn. So these can be rabbit holes that it's hard to extract from. I assume that everyone tackling these issues is doing so in good faith, and I think reasonable people can come up in different places. I'm happy to answer specific questions, of course, when we get into the Q&A, but I thought it might be helpful to lay out some kind of general principles that I think unite a lot of these topics that have been listed here. So the first is that when speech and privacy clash, it's both an area of law that's been explored, but is, I think, somewhat unmoored from general principles. The Supreme Court, every time it gets a case where speech and privacy are in some tension, it kind of ducks and does so explicitly. There's language in almost every case that involves speech and privacy together where the court says, we're not ruling any more broadly than we absolutely have to with our feet to the fire in this particular case. So those are cases about newspapers, for example, disclosing photographs of accident victims, names of rape victims, papers or media organizations that have publicized recordings that were intercepted illegally. These are thorny questions, right? These are images or recordings that may, on a gut level, clearly violate someone's privacy, but the media has deemed them of public interest and has printed them to inform the populace. And of course, there's the matter of public figures. So for example, one person's revenge porn may be another person's fodder for a re-election campaign, right? Depending on whether the person pictured is a private person or someone who's running for re-election who is in a state in flagrante delicto. So those things matter to the court. How much the public has a right to hear about that information really depends on whether it's your next door neighbor or whether it's Anthony Weiner. That matters legally, and it's very important to keep that in mind. Second, I would say that the court has pretty clearly, especially in recent years, taken a very different approach to civil and criminal law. In the civil law, the court seems to accept, many courts, not just the Supreme Court, the idea that the civil law can kind of parse out the messiness of interhuman behavior, right? How we interact together, when we treat each other badly, when someone, for example, has inflicted emotional distress on you, when someone has committed defamation of your character. The civil law can take into account the kind of all the details that may play into that human relationship, into the intent, into the impacts. The court has been much less forgiving of laws passed in the name of privacy or other very valid goals that criminalize speech, even speech that isn't clearly on a matter of public concern. Most notably, the U.S. v. Stevens case, which is really a very distressing case in its facts, but from 2010, where effectively the federal government tried to pass a law to ban what's called animal crush videos, the absolute most distressing form of speech that many of us could think of, which is effectively images of animal torture. And the court said, you can't criminalize this, and you don't even necessarily have to prove that all the speech that this is criminalizing is valuable speech. It's not enough to say, the law actually had an exemption for valuable speech, and the Supreme Court said that's not enough. So these limits are real, right? It's not just the ACLU being concerned about the potential for privacy legislation to impact speech. The federal courts have also expressed that concern. So these, I think, the issues that were listed in this topic array along a spectrum of kind of, I think, easy to hard in terms of how thorny the legal questions get and where the line can be drawn in protecting privacy while making sure we're respecting the right to free speech. And I think there are some big guidelines, and I'll try and refer to the individual topics as I go through. The first is, and this is most relevant to harassment laws, I would say, that the First Amendment does not permit restrictions on speech because it annoys someone. That's a pretty basic tenet at this point. And particularly in harassment context, we've seen many states, I think, slipping back recently and passing cyber harassment laws that do use an annoy standard, right? So you print something about someone that annoys them. Those are pretty likely unconstitutional. The word annoy is inherently vague. And the First Amendment doesn't mean much if it doesn't protect annoying speech. So, well, that's really true, right? I'm a free speech attorney, and I've never had a client who wasn't annoying. That's just the reality of my work. And I'm on live TV. Sorry, clients. Okay. But that is the reality, right? Nobody is going to stop your speech because you're protesting about puppies and rainbows. Instead, it's the Fred Phelps of the world that really developed the First Amendment jurisprudence. And that's really the trick to doing this work, is that sometimes, everyone loves to say to a free speech lawyer, no one loves the First Amendment more than me, but, and it's that word but, right? And it's always in the context of specific speech that we all on a visceral level just find so appalling and annoying. That's not enough to criminalize it. Second, intent matters, right? If we think about defamation, the impact to your character might be exactly the same if someone writes an article assassinating you and it's totally untrue. But if they didn't know, if there was no fault there, right, it was a simple error, you can't criminalize it. That's what the courts have said. If, however, you're a private person and they go after you and they should have known better, that can be criminalized, right? So intent is a big divider in how the courts will view these laws and whether laws that are passed in the name of privacy or other valuable goals are going to pass constitutional muster. And the reason is because it tailors it to truly bad actors, right? When we think of harassment, when we hear that phrase revenge porn, it calls to mind this malicious actor. What's really critical is that the laws also are specific to malicious actors. And that I've seen most troublingly in the revenge porn context. As I said, revenge porn, it's a very difficult issue to talk about. The phrase itself, no one in their right mind is pro-revenge porn, right? But the devil is in the details. And I, as a lawyer, you as legislators, I think, have a duty to get dirty with those details, particularly when there are consequences for free speech on the other side if those details aren't well thought through. So, for example, Arizona recently passed a law that makes it a felony and frequently a sex offense to post an image of another person who is either nude or engaged in a sex act when you know or should have known that the person did not consent to the disclosure. Under the plain language of that law, I would be a felon for printing photos of abuse at Abu Ghraib, for printing photographs of Holocaust survivors who may be nude, for linking to an image of the iconic photo of a girl fleeing napalm in Vietnam, okay? That's not a well thought out law. So I encourage you when you're on these very fraught issues to be mindful of the details, because I don't think there's bad faith behind that law at all. It was passed unanimously. It sounded really good. The problem is the impact of that law absolutely sweeps in protected speech. So the key is to get the details right on this kind of legislation. Public concern, as I mentioned, gets the greatest protection in the law. It's a little mushier when it comes to criminal laws, but certainly in terms of civil law. How much the public has a right to this information really, really matters, right? And that, particularly on online impersonation, that's a big dividing line. So with regard to impersonation, if you're impersonating a private person, if you're doing any of the things that Jeff just talked about, right, going after someone to make a profit, to hack into their systems, to impersonate them as a user, that's pretty clear cut. Those aren't speech issues. Nobody's going to file a First Amendment lawsuit if you pass that law. But if you pass a law that makes it illegal to run a parody account, a parody Twitter account of a public figure, that, of course, would be unconstitutional. I recently took some pot shots at the mayor of Peoria, Illinois, because he asked his police force to engage in a SWAT team-style raid on the house of someone who was hosting a parody Twitter account of him, using his name and using his image. I'm sure it was uncomfortable for him, but the reality is, in being mayor, he signed up for a higher degree of public scrutiny and, frankly, a lower degree of protection from laws like impersonation because he's a public figure, because the First Amendment protects our right to mock him, even if it's annoying. And I understand that's uncomfortable, and God bless all of you for entering the public realm and subjecting yourselves to that. And I promise I won't run a parody account of anybody here today as long as you're nice. All right. The next principle is that there are some built-in financial incentives for industry to file lawsuits, even if the ACLU thinks you get the balance right. And that's just something to be aware of. This has come into play largely in other speech versus privacy contexts that are offline, such as automated license plate readers. There have been some First Amendment lawsuits filed by those companies. Online, I suspect the next wave will come from mugshot websites. They're highly profitable, and many states have recently passed laws that restrict their ability to charge for either posting or taking down mugshots, kind of reputation control sites. Now, mugshots is a really tricky issue, and it feeds into my next point, which is the government doesn't have First Amendment rights. That's a big principle to remember. Where the data that may be the nub of the privacy you're trying to protect is in the government's hands, the government has much more discretion in being thoughtful about how they release that data. So, for example, voter registration records. Most people are familiar with the fact that most states have restrictions on who can get those records. They can be given out for educational, charitable, nonprofit purposes, but in most states, for-profit folks can't get voter registration records. They can in some, and those have generally not been challenged. Similarly, mugshots do not have to be released before conviction. They certainly don't have to be released digitally en masse to for-profit companies. So I think we've seen somewhere in the ballpark of about 10 mugshot-related bills in the last couple of years. Some states have made it illegal to charge money to take down a mugshot. That, I think, might have some constitutional infirmities. And again, even if the ACLU isn't riled up about it, those are profitable companies who may have a lot at stake and may go into court and seek to find those laws invalidated. The reason that's tricky is because the government has already released that data into the public realm. So it's very, very hard for the government to now make an argument that there's an acute privacy interest in those records. The government made it public, right? What the government can do is restrict its own actions. It can restrict who has access to those records. It can do what some other states have done, which I think is much more creative, and not make those records available to people who run basically for-profit privacy violation machines, like the mugshot.com style websites. But there, again, when we come down to public figures and public concern, it's not so black and white, right? There are, Rick Perry's mugshot was certainly in the news in the last couple days, and I suspect that many people in this room either viewed it or shared it. I think we have an innate understanding that that's a matter of public concern. This gentleman has certainly not been convicted. And so, we look at the mugshot of someone like Rick Perry, or, the quote-unquote revenge porn of someone like Anthony Weiner in a different legal context than we look at the mugshot of the next-door neighbor or the revenge porn that's been hacked or stolen from a private person. So those analyses have to differ, and I think legislation has to be sensitive to that. And that doesn't always mean in the legislation saying, having the Anthony Weiner or the Rick Perry exception, but it means focusing on the source of that data. It means focusing on intent, particularly when you're passing criminal laws, and narrowing these statutes to malicious invaders of privacy. That's really the key. And if there's anything you take away from my talk today, that's what I would say it would be, is that when you're talking about speech versus privacy, the best way we can balance those two equally valid and competing interests is to focus on malicious invasions of privacy. If we focus on people who are bad actors, and we focus on data where people have a reasonable expectation of privacy, if you put those two together, I think you're very unlikely to have many of the constitutional problems I've just alluded to. Now, the last thing I want to end with is to kind of look at Europe for a second and illustrate the alternative, right, of a world without the First Amendment. And what that world, I'm sure many of you have heard about, but the European Court's recent decision on the right to be forgotten. The European Court effectively issued a decision saying that a lawyer, a Spanish lawyer, who had his property sold at a tax auction because he had a lien on it and wasn't paying his taxes. There had been an article written about him about, I think, 10 or 11 years prior. And he didn't like it because it was hurting his business. I can't imagine why. He petitioned the European Court saying that it was violating his privacy rights to continue to have that data living forever on the internet, and the court agreed in what I think is one of the more ill-thought-out and pernicious global decisions in a world without a robust First Amendment. Since that decision has been issued, we already know, and I'm really looking forward to a more systemic breakdown of what these requests look like. We already know that folks who are using that system are folks that tend to already have power, access, influence, lawyers, and they're requesting things like, this is bad for my business. This old article that was written about our entire board of directors being fired because we stole things from the public trust, that's really hurting our business. Please take it down. Because in America, our First Amendment right robustly protects matters of public concern and public figures, there is no way that any court in America, I hope, would ever say that an attorney who is serving in a position of public trust, who had a public tax lien, and that was reported in a public newspaper, that he had an expectation of privacy in that article. I don't think that could happen because of our First Amendment, and I think that's good. In Europe, companies like Google are now reeling with the volume of these requests and figuring out how they're going to grapple with them. And I mention that just to say that I think sometimes privacy and free speech come at costs, come at a grave cost. Our Supreme Court has actually recently kind of blatantly said that, which I think takes some guts. In its recent cell phone decision, it said this is tough, and this may hinder some things that law enforcement would like to do, but privacy comes at a cost. That's true. It's also true that speech comes at a cost, and that cost can be annoyance. That cost can be public scrutiny. But those realities have shaped the democracy that we are. It animates what America is, what our founders put down. So they're not just tropes. So I just ask you, on all these issues, when you're thinking through them, I know they're difficult, but don't be afraid to grapple with the details, because they matter, and they matter constitutionally, they matter for businesses who are impacted by them, and they certainly matter to the courts. Thanks.
Great. Thank you, Lee. And I'm Representative Jeff Morris. I want to thank Representative Zuber for launching this session without a co-pilot, so thanks for doing that while I was detained down the hall. Next, we'll hear Jim Halpert. Mr. Halpert leads the U.S. private and security practice of DLA Piper U.S. and co-chairs the firm's global data protection, privacy, and security practice. He counsels companies on a broad range of data management issues, including cyber and data security, navigating difficult conflicts between foreign privacy laws and U.S. compliance obligations, and regulation of advertising, marketing, and privacy practices, among others. Representing a coalition of Fortune 500 companies, Mr. Halpert has been involved in drafting U.S. state privacy as well as federal internet privacy laws. He received his Juris Doctorate cum laude from Harvard Law School and a BA magna cum laude from Yale University. Please welcome Mr. Jim Halpert.
Thanks very much, Representative Morris. So Lee gave you a really helpful First Amendment tour of the different types of sort of online vice and bad behavior that we're talking about today. And I'm now going to give you more of a view of what states have done and some of the non-First Amendment considerations that come into play, although I wholeheartedly agree with much of what Lee said with regard to First Amendment limits. And I would actually emphasize, for those of you who are thinking of drafting laws, to keep these in mind, because in effect, if you draft something that violates the First Amendment and somebody comes along and sues, you wind up under federal civil rights statutes having about a $500,000 or $250,000 to $500,000 taxpayer expense paying the lawyers who went and sued to strike down your law. And in the end of the day, your citizens, the citizens in your state, are no better because the law struck down as unconstitutional. There can be very well-meaning laws. There was one in Vermont that involved restricting information about prescription drug purchases by consumers that was struck down as unconstitutional in the Second Circuit Court of Appeals, and is totally ineffective. And it went up to the Supreme Court. The Supreme Court didn't reverse the decision. So once information is out in the clear, if you try to regulate it, even its disclosure, that's a form of speech. It's much more difficult to pass something that's going to reach constitutional muster. And the mugshot issue is a great example. Even as a practical matter, if you make as a state, or you allow local law enforcement to post on the internet mugshots, those can easily be copied, can go to, Japan or go to Australia or some other place where it's very difficult for a U.S. state to have anything to do to bring that information offline. Once information gets out on the internet, even with the European right to be forgotten decision, which is hitting, it was targeted at U.S. search engines because there are not a lot of European search engines. But even if information is removed from Google and some of these other indexes, it's still going to be online in other places, and that decision doesn't even try to do that. So once information is out there in this world of instant copying on the internet and free emailing of information among different people who are connected to the internet, it's pretty much a losing battle to try to pull it back. The approach of Georgia, which is to say mugshots are should not be publicly released is probably the most effective way to deal with the problem. It also avoids all these First Amendment issues because the government has actually produced the information, owns it, controls it. And if you think about it, if somebody is arrested, that doesn't mean that they've been convicted. Most arrests do not result in conviction, and it can be highly prejudicial and misleading, actually, to put out one of these mugshots before someone's been convicted. There are arguments in favor of doing that, but if you're concerned about this, think about keeping the information from being placed online. I personally think that charging for removal of a mugshot photo is pretty slimy behavior, and these companies may well sue, but I have a feeling that courts are not going to be all that sympathetic to them for doing that. Interestingly, the members of the coalition that I represent, who are mostly mainstream internet and media companies, none of them charges to remove a mugshot, and when they looked at this, everyone thought, that's a great idea. But moving on to revenge porn, this is, clearly an animating and issue of concern. I know, Representative Morris, you've sponsored a bill on this. I do completely agree with Lee that having a high intent standard is important. It's also important that the photo of the person have been taken when they expected it to remain private, or they were unaware of being filmed. I've seen some versions of these bills that would essentially allow porn stars to go, in addition to mounting a copyright claim, they'd voluntarily appeared, been photographed, and they could assert a revenge porn allegation or claim against some entity that was some person who was disseminating. That's a copyright infringement issue. It's not really a revenge porn issue. Turning to the issue of online impersonation, it's very important to understand that people can choose to communicate using a different screen name, for example, and you don't want to prohibit that sort of activity. Also, that there is probably a constitutional right to adopt a username that you prefer, just as you have the right to change your name. So you need, as you think about online impersonation, you need to think about things that are really duping individuals. There are a lot of states that have prohibited phishing. I helped to draft a model law that I think has been adopted in quite a few states. I don't know that it's all that effective because people doing phishing are located outside the U.S. and pretty rarely are you going to have someone in the U.S. doing this, but that's totally legitimate. Where you're scamming people through your impersonation, or if you are in a regulated business, not all businesses have to do this, where you need to identify yourself and you falsify that information, that would be a violation of law and could legitimately be prohibited. You don't want to prohibit, though, some business that decides to have a new sort of marketing name for a particular service offering that they're coming up with. They might go and trademark that, from not identifying themselves as being, the Procter & Gamble company's particular provider of this brand. It's important as you draft all these things to draft them narrowly and to aim at what you really want to prohibit. Otherwise, you wind up with this expensive lawsuit and the thing gets struck down as unconstitutional. That's not to say that states haven't done that successfully. I'd also point out that most internet companies prohibit falsifying your identity online, not all. But they enforce this restriction really where there's some sort of harm that's ensued. And similarly, if you're thinking about online impersonation being prohibited, it's really important to think about some real concrete harm that's been suffered. Someone's been defrauded, for example. As to the issue of privacy invasions, generally speaking, states have not been very successful in passing particularly internet privacy laws. A lot of them get struck down because they are regulating speech or discriminating against different speakers. That was the case with this law in Vermont. There was one law that passed in Maine that the state AG prohibited collecting or disseminating information from teenagers online. The state AG, when a lawsuit was filed, agreed to settle it rather than defend the constitutionality of it. Utah passed an overbroad spyware law in the middle of the 2000s that resulted in a lawsuit, and the state had to pay attorney's fees to the New York law firm that brought this lawsuit because it essentially regulated all downloads of software that were not that someone hadn't consented to. There are all sorts of reasons why even internet security software will send updates on a regular basis, and you don't need to get consent for each of those sorts of downloads. In terms of harassment, Lee is absolutely right that one person's annoying speech is not really harassing speech from the perspective of the U.S. Constitution. It's also important to understand that online terms of use generally prohibit harassing other users, and that if a user engages in repeated, really extreme behavior, in certain of these fora, you can actually go to the internet provider and explain that someone's really being harmed by this sort of harassment. You'll find that the internet companies are quite responsive to that in many cases. States have laws that prohibit things like cyber stalking, cyber harassment, and cyber bullying. It's important, again, to draft these in a targeted way and focus on harm to individuals. Severe, for example, intent to inflict severe emotional distress might be an example, or causes somebody to fear for their safety. Those sorts of standards in harassment really get to something that is concrete, that courts will uphold, and that will protect against the harms that I think most constituents and legislators are concerned about. Finally, as to hacking, Jeff gave a really good presentation on the challenges in this area. I can say, and I'm not being paid to say this or anything, but our law firm, which is this huge global law firm, uses Dell's SecureWorks in order to help stay up with online threats. I think there's an important lesson here, though, as you think about security and cybersecurity online. This is an incredibly dynamic landscape with a lot of innovation by attackers and expensive but important innovation in defense. But it's much cheaper to attack and to share information in these hacker forums than it is to get together and collaborate with many different players in the internet ecosystem to upgrade security. But turning to what states do in addressing hacking and cybersecurity more generally, it's important to think about this innovation. Minnesota passed a law in, I think it was probably 2008 or 9, at the request, I think, of state based credit unions or smaller credit card issuing banks that said essentially, if you're a merchant who accepts payment card transactions, you can't keep the magnetic stripe data that comes across when you get, or the CCV code associated with a credit card, for more than 48 hours. And if you do that and you suffer some security incident, the credit card issuing bank can sue you. That's great. It's a good security practice. The whole payment card networks have issued a long set of security commitments that any entity that accepts payment cards needs to follow. The problem with hacking and with security challenges is that hackers are highly innovative. So we read about this huge volume of payment cards that will be acquired by hackers. This is in an industry that's really subject to one of the most extensive and very specific security set of security requirements imposed by contract in order to participate in the Visa, MasterCard, Amex, and other payment card networks around. But that's not enough to stop hacking because there's so much innovation. So if you think, and Nevada is a good example of this, they were asked by RSA and some other entities to pass a mandate to encrypt data when it left the premises of a company. That encryption is fine, but if the encryption key is stored with the encryption, it's totally ineffective. So this is part of Nevada law. I don't think there's been any litigation over it. But there's no silver bullet that's going to assure information security. What states have typically done, and I think it's a much better approach, is to require reasonable security practices and procedures to review what's going on. Oregon actually has a good law on this that it passed with its security breach notice law that requires ongoing review of and risk management to assess the sorts of risks really that are presented to your system. More specific requirements typically actually hinder innovation because people just design around the particular legal requirements, and they're not thinking in the forward-looking 360 way that Jeff described before. Finally, with regard to hacking, most states have anti-hacking laws. Some of them are drafted in an overbroad way that Lee probably wouldn't like very much, that prohibit any sort of download or communication of information without the consent of the recipient. Those are probably unconstitutional. But these hacking laws, some of them are well drafted, focus really on hacking and other sorts of damage to computer systems that are being imposed intentionally by some bad actor. But it's very hard to actually bring these enforcement actions because the really sophisticated hackers are located in places like Russia and China, and state AGs are just not going to be able to get jurisdiction over these folks. So it's important to think again about what the harm is, who's doing the bad thing that you want to prohibit, and to develop a solution that's aimed at that. State laws can be very effective against people in the state who are doing inappropriate hacking behaviors in computer systems, but that's often a different sort of player than a state-sponsored, for example, Red Army hacking division that's trying to get trade secrets to help out Red Army-owned businesses to do better against U.S. companies. And it's important to understand the limits of what you can do at the state level, and also to think through how are we going to avoid having something be invalidated, we'll just waste money, and actually protect our citizens. So all these issues are hot, sexy issues. You want to be out there and come up with a bill to do that, but it's important to think carefully about it and figure out what's really going to be effective, what's really going to be able to reach behavior in the United States that states can do something about, and how to do it. It's also important, if you care about things like cybersecurity, to think in other areas whether you may inadvertently be interfering with cybersecurity. A great example is of this sort of unintentional consequence are in employee social media privacy bills, which the coalition I represent has actually worked with the National ACLU to come up with a model approach that's moved in Oregon and Washington, a bunch of other states. It needed an exception for picking up, the prohibition was against requesting or acquiring user login information for social media sites. Well, in the course of scanning, the sort of scanning that Jeff described doing in networks, the employer or its agent may inadvertently, because they're filtering all the traffic that's going through the network, acquire the username and password just because they're looking at all the information that's going through the network. It's important to have an exception for security monitoring, or maybe you say there are other ways of rephrasing the prohibition. But as you think about these online threats and privacy problems, thinking in this sort of 360 way about, well, by doing X, am I actually going to interfere and discourage monitoring for security purposes, is a good thing to think about. Turning to Europe, there are European privacy laws that in countries like Germany that treat monitoring as this huge intrusion on privacy and require that the labor union or works council sign off on whatever sort of monitoring is done, and that the monitoring be done in Germany and only be done for very limited purposes. So as a consequence, German companies' computer networks are generally, if they comply with European privacy and labor laws, are generally much more vulnerable to attack than U.S. ones. And so as you think about this, I urge you to think deeply and do this sort of 360 review of the different consequences of proposals. Anyway, I hope that was helpful, and happy to answer any questions.
Great, thank you, Jim. Thank you, Jim. All three speakers did a really outstanding job at sharing their expertise in this very complex area of law. We have about 10 minutes for Q&A, and if you'd like to ask a question, please come up to one of the two microphones and be sure to state your name and what state you're from, and who you want to direct your question to. And if anybody wants to start shuffling up, maybe I'll ask one question just to get started. And any of you can jump in on this, but one of the areas that we've looked at, trying to stay away from, some of the areas that you've touched on in all of your presentations, but Lee, you in particular, is looking at what like California's done, where they've extended some trademark type laws into the paparazzi type space, and it seems like that's a more a substantial, firm ground to stand on and moving forward with some of these issues that we've talked about as far as revenge porn and some right to control your own kind of biometric information moving forward. So in essence, almost like a trademark for your face. Could you comment on those laws in that area and your thoughts on it?
Sure. Is it? I feel like I can hear myself. Can you guys hear me? I'm not sure if this is on. Okay. As a general matter, first and foremost, as I mentioned before, I know we have some more flexibility, as do the courts, with civil laws, in part because, at least with regard to the copyright regime, it incorporates the idea of fair use, right? So all that stuff I mentioned about public figures, about matters of public concern, the courts have basically ruled that is inherent to the copyright system. Now, not to parse hairs too finely, but I don't think that applies to the trademark system in the same way. The trademark system, of course, is, I think, getting a little moment in the spotlight right now, in part because of attention paid to the Redskins trademark and the kind of fight back and forth about whether or not that will be denied. Trademark, unlike copyright, doesn't have the same kind of long tradition of incorporating these constitutional concerns, and it does give me more concern that those calls are made more arbitrarily. But that asterisk aside, yes, I think that copyright and trademark do provide an avenue where people have more control over their image. And there are already some common law and state laws called right of publicity laws that basically give people a private right to stop people from profiting off of their face. Very interestingly, one of my friends was recently included in a BuzzFeed list, BuzzFeed being a website that basically collects things from around the internet and kind of looks at, say, Facebook trends or hashtags on Twitter and does kind of lists about the top 30 people who use this hashtag. And she wasn't asked, no one talked to her about it. And it was interesting, as her friend, as a First Amendment attorney, as a privacy attorney, I really grappled with this, right? I mean, this is a tough question. They're kind of making a pseudo-newsworthy list on the backs of a bunch of private people by aggregating it. So I think things like right of publicity are great because they don't make that criminal, right? But they do prevent someone from BuzzFeed from profiting, right? Their entire business model is to put up your image. That's a problem. And my heart's not going to bleed if they're not permitted to do that, right? So it's not, and it's similar to what Jim was mentioning about the mugshots and the distinction between charging and not, that when it's fundamentally a profit motive, I think there can be an argument made that the acute free speech interest is lessened somewhat, right? They're not making that speech just to be expressive. They're doing it to turn a buck. So I think that plays into the analysis. But also, the civil law allows you to control things in a way where you just can't be monetized without your permission. And I think that is a principle that protects privacy without unduly infringing on speech. And the last note I'll make on that is there's a professor named Derek Bambauer at the University of Arizona who has actually proposed an amendment to copyright law to give those who are pictured nude a copyright in their image, because right now copyrights only go to the maker, the photographer. So ironically, in some ways, people, but women in particular, have more protection over selfies than they do over an image that they might allow an intimate partner to take and keep, and then that partner shares it. So these are things we need to grapple with, and I think creative solutions in copyright, we should look for them because they're ways to avoid the criminal consequences while maybe seeking relief where those images are actually taken down, which I should note the criminal law doesn't do.
Jim, do you want to jump in?
Yeah, thank you. I'd add that the right of publicity actually has proven to be pretty controversial in proposals to extend rights of publicity that have come up in probably 7 or 8 states over the past, say, 4 years or so, because there actually are some First Amendment type rights. This is not in the context of some embarrassing image that as to which there really is some form of harm that somebody's suffering. But proposals have made it impossible, for example, would have made it impossible to refer to the George Foreman Grill as the George Foreman Grill in a comparative advertising proposal from the XYZ Grill that wants to compete. And you do have in the commercial speech context some really valid interests in giving consumers information about different products. And I'd say that so I just qualify a little bit what you were talking about. Typically, that does not apply in the context of some hugely embarrassing nude image of somebody, and then you use that to sell the product. But there are some limits, and the right of publicity is not a silver bullet where you can just create huge rights for individuals to control their names.
Great. I think my co-chair actually has a question. Oh, actually, I'm sorry, you were in my blind spot here. Go ahead.
Sorry about that. My name is Barbara Fleischauer, and I'm a legislator from West Virginia. And is there anybody from North Carolina here, by any chance? My cousin is a disabled person who lives in North Carolina, and I'm going to ask a question about the mugshot laws. She lives next door to a crazy person who has had her arrested twice. Once because she went on this woman's porch because the woman's cat got into a vent in her house. And a second time because she hung a bird feeder on the 6-foot fence this woman put up for whatever reason. And the second time, so North Carolina has this law that allows civilians to get a warrant for arrest and get you fingerprinted and your picture taken. And so my cousin's picture was put up, and they had some kind of crime bozos. And so she went to the grocery store and said, "You were just on Crime Bozos," or something like that. And I guess I'm a little more interested now in these mugshot laws because it was so, I mean, my cousin's on Social Security. She can't afford a lawyer. This was hugely traumatic, I mean, in part because they even have this provision that allows private citizens to get ridiculous warrants, but also because then, someone in her community, recognized her the same or the next day. So I'd like some more information on those mugshot laws and which ones are good. It sounds like the Georgia one may be pretty good. And also the flip side of that is I would think there would be a real public interest in the governor's mugshot. So how would you draft one given that if somebody got a hold of the governor's mugshot?
It's possible to draft an exception where there's a matter of significant public concern, but essentially you can work off of the Supreme Court standards where there really is much stricter scrutiny of restrictions on speech and build that in. But I personally think that's a really good idea.
So the Georgia law is pretty solid, and
I'm
it
not
would
sure
be
that they have that exception. I just don't have it handy. But in general, the presumption that that mugshots should not go onto the internet, should not be released to the public until and unless someone's been convicted, I think is a pretty sound privacy principle.
Yeah, and I'd agree. And one more recommendation I'd have is the federal FOIA law actually has this built-in balance. So the federal government's policy is not to release mugshots before conviction, but there is and they deny it when you FOIA it because it violates personal privacy. They basically have a sliding scale. Is it more difficult to administer? Certainly. So, I'm not claiming this is easier, right? Because they have to, when someone challenges it, they have to make an ad hoc call. But it does recognize exactly what Jim just mentioned, that when there's a heightened public interest. And I would note, by the way, that I really do think a lot of the things we're talking about, whether it's mugshots or revenge porn, what's behind all of these is the pruriency of images, right? It's a weird and more philosophical thing to think about, but I don't think they'd be selling Crime Bozos if what it was plain text descriptions of X person called the cops, right? There is something about an image that has power and is sellable. It's marketable. So, I think having arrest data is critically important, right? It's how we make sure that our processes work. You might want to take another look at that private arrest warrant law. We want to make sure that people aren't racially profiling, right? That they have probable cause when they're arresting people. So the data, I think, is important. But do we really need the image? I think there's a tougher case to be made there unless there is a situation where the public has a right to know or a real concern in that. FOIA law gets that right. And it's one place to look.
And just to follow up on the Georgia law, because I assume that's a ban, you don't need to worry about the issue of making money off of it.
Right. If it doesn't get out there, people are not going to monetize it.
Okay, thank you.
Great, thank you. We're out of time for this session, actually. I wanted to take a second to, again, thank our three panelists. Let's put our hands together for the great information they shared with us. This will adjourn this session of on online threats and dangers, and there's some other good sessions this afternoon. We'll hope you take those in as well, so thanks.